Okay, can you see that?
Yes.
Okay, my apologies for that. I'm not quite sure how that happened, but let's start over again. So we're talking about, I just want to go to the correct slides. Oh dear. People, this is not, my laptop is not working, and this is not the slideshow that I want. What do you suggest? Do we continue struggling, or do we call it a day? We've got a whole revision week next week before your next quiz, so we can do this on Tuesday. What would your suggestion be? Do we continue struggling, or do we call it a day? So I don't want to waste your time.
Ma'am, can't you try again? Then we can do the revision that for the 2 days, Tuesday and Thursday.
Okay, I'm going to try once more.
Yes, please.
If it doesn't work this time around, then we need to give up.
Does all the students here have the study guide, or maybe the slides in front of them, while you can just teach us without, if you don't come right, so we can follow, or maybe.
Yeah, I can try that, but I don't actually like teaching without having the slides. Can you see? I can see something in front of me now. Can you see that?
Yes, I can see the Unit 15 auditors.
Okay. Going to jump to that slide. Okay, liability of the auditors. Is that the one that you've got in front of you?
Yes.
Okay, great. Sorry for the struggle. Thank you for your patience. So let's start all over. Liability of the auditor. Going to start off by telling you a story, a real life. I've already spoken about what's happening with PwC China at the moment, but a more close to home, a real life Namibian story. It's not a story, it was an actual court case. The High Court of Namibia. Quite some time ago, the matter was eventually settled out of court. There isn't a judgment that I can refer you to, but it was quite widely publicized in the papers at the time. An incident happened as I said, some few years ago, where the Namibian Airports Company, over a number of years, I think it was something like a period of 3 years, the financial manager of the Namibia Airports Company had systematically been defrauding the company by opening false accounts in his name and making unauthorized transfers, etc., etc. He had ended up pocketing quite a couple of $1 million. When eventually he was found out, and obviously fired and charged with fraud, etc., etc., what this financial manager did is he took a gun and he put a bullet through his head. So he could not be held. Of course, the money that he'd stolen was no longer in his bank accounts, because people that steal money don't keep the money in their accounts. They don't put it in a savings account. They spend it. So these millions that had been stolen by this financial manager could not be recovered from him or his estate because he was dead and the money was gone. Of course, the Namibian Airports Company wanted to see if they could recover as much as possible of the money, and they subsequently instituted legal action against both Bank Windhoek on the basis that Bank Windhoek should have checked that these accounts were authorized, should have picked up whatever, but not only against Bank Windhoek, also against their external auditors, which also happened to be PwC at the time, on the basis that PwC had been negligent by not picking up the fraudulent accounts over the period of 3 years. They alleged that if PwC had done a proper audit and had not been negligent, this fraud would have been picked up in the first year already, and they would not have continued for 3 years, and they would not have lost that amount of money. So, apart from PwC China, an actual Namibian example of a company wanting to hold their external auditors liable for not performing a proper and professional audit. So that is what we're looking at tonight, the liability of the auditor. Now, if somebody wants to claim from the external auditor, the first question you need to ask is, who wants to claim? Is it the company itself? So the Namibia Airports Company in the example I gave you, or it can even be a third party. There's a very, very well-known court case of quite many years ago, International Shipping versus Bentley, 1990, which is the classic case of a third party wanting to hold the auditors of another company liable. What happened in International Shipping is that International Shipping had advanced money, had lent money to another company, D, just call it D company. They entered into these transactions with D company based on their audited financial statements, which reflected positive financial affairs. So by looking at these financial statements, it seemed as if D company would be able to repay this loan because they seemed financially sound. Made this loan to D company, and not too long after that, D company was declared insolvent, and International Shipping stood to lose the money that they had lent. They then alleged that Mr. Bentley, who was the external auditor of D company, had been negligent in the preparation of the checking and signing off of the financial statements, and had not done proper checks and had not picked up that these financial statements were actually incorrect, and was thus liable and should repay them. So if you're talking about the civil liability of the company, you need to distinguish, specifically also in assessments, if I give you a case study, distinguish between who wants to claim, who wants to hold the external auditors liable. Is it the company itself, the company that appointed these auditors, who are alleging that they suffered a loss as a result of the auditor's failure to detect fraud or properly verify the existence of assets or whatever, generally not doing what they're supposed to do? Or is it a third party, an outsider, who similarly alleges that they suffered a loss as a result of relying on the company's financial statements to make a loan, to buy shares, to do business with the company, and that the external auditors had signed off these financial statements and had not done proper checks, had not verified, etc., etc. Now, why do you have to distinguish? Because the claimant, whether the claimant is the company or the third party, is going to make a difference in the legal basis of the claim. If it is the company itself which wishes to claim, they can institute their claim on two possible legal grounds. In most practical instances, they will use both. They will say it's either that or that. The company itself can base their claim on breach of contract. Because when the company appoints their external auditors, it is an implied provision of this contract that they must act with reasonable care and skill and in accordance to international auditing standards. If they don't act with reasonable care and skill and in accordance with international auditing standards, they are literally in breach of their contract. There's a contract, they're supposed to do something, they don't do it properly. Introduction to Law for Accountants or Commercial Law 1A, of those of you that did that. There's a contract, you undertake to do something, you don't do it properly. That's breach of contract. It's literally defective performance. In order for the company to succeed with a claim based on breach of contract, they have to prove three elements, which are stated there as those three bullet points. They have to prove, firstly, that there was a contractual relationship between them and the external auditors. That is obviously fairly easy to prove if they appointed the external auditors, if the external auditors were appointed by them at their annual general meeting, a contractual relationship immediately arises. Secondly, they have to prove that there was breach of contract. So they have to prove the auditor's negligence, failure to act with care and skill, etc., etc. And then, as is the case with any breach of contract case, they have to prove the actual amount of the loss that they suffered. In addition to being able to base a potential claim on breach of contract, they can also base their claim on the law of delict. Now, you haven't studied the law of delict in detail up to now. You did briefly, right at the beginning, introduction to law, those first units, you were briefly given the definition of a delict, but you haven't studied delict in detail. But to remind you what a delict is, a delict is culpable, wrongful, culpable, so it's blameworthy, wrongful conduct by a person which causes damages and gives rise to the liability to compensate. So when you commit a delict, it's a culpable, wrongful act which causes damages. Now, in order to succeed with a claim based on delict, there are 5 requirements that the plaintiff, in other words, the company, has to claim or has to prove. They have to prove all 5. If they can only prove 4 out of 5, they will not succeed with their claim. You have to know these 5 elements. I have literally asked you in your exam, what must they prove? So what must they prove? The first element is conduct, the act. The act, and be careful here, the act refers to something that the auditor did or didn't do. So the conduct refers to the fact that the auditor failed to act with reasonable care and skill, or failed to act in according to international auditing standards. So they need to firstly bring evidence to court what the auditor did or was supposed to do but didn't do. Secondly, the second element is wrongfulness. So wrongfulness describes the conduct. They have to prove that whatever the auditor did was wrongful. Be careful, the word is wrongful. It's a legal term. It's not wrong as in incorrect. It's wrongful. Wrongfulness describes the conduct. An act will be wrongful if it infringes a subjective right. So the company had the right to have the audit performed in terms of international audit standards. If the auditor didn't do so, this act, him performing the audit, was wrongful. So it's a wrongful act, wrongful conduct. Third requirement is fault. Don't confuse wrongfulness with fault. Also, in this regard, be careful. Fault is a legal term. It also doesn't mean mistake. So don't tell me he made a fault. Fault describes the auditor's state of mind, whether whatever he did, this wrongful act, did he do it intentionally, on purpose? In most instances, that is unlikely that an auditor would commit a wrongful act on purpose, because then obviously they will definitely be scrapped from the role and lose their registration. So a most likely scenario is that they were negligent. They did not take care. Were not careful enough. So the company needs to prove that the auditor negligently did this wrongful act. Furthermore, they need to prove the amount of damages. That's the financial loss suffered. That's fairly pretty straightforward. And then the last element that they must prove is the element of causation. That the wrongful act, the negligent wrongful act, caused the damages. That there's a link, a direct causal link between this negligent wrongful act and the damages suffered. Another way of putting that is that the company would not have suffered these damages if the auditor had not done this negligent, wrongful act. Only if you can prove all 5 those elements will the company succeed with a claim against the auditor. But we saw that sometimes it's not the auditor, it's not the company that wishes to claim, but an outside party. If it's an outside party that wishes to claim, they cannot base their claim on the law of contract, because there is no contract between the external auditor and an external user of the financial statements. In other words, a third party will have to base their claim on the law of delict. If it's a third party, however, that wishes to base their claim on the law of delict, your requirements that they have to prove are exactly the same. So both the company and a third party can claim against the external auditor based on the law of delict. Company itself has an additional legal ground to claim, namely the law of contract. Have to prove all 5 these requirements. And the one that normally sinks the case is the issue of causation. I started off by illustrating to you, giving you the facts of, and this whole case is also discussed in your notes. Don't need to remember the name of the case or anything, but please do go and read that example there where I've discussed the international shipping versus Bentley. International shipping versus Bentley. International shipping had lent money to D Group. D Group subsequently was declared insolvent, went bankrupt. They alleged that that Bentley, the external auditor, was negligent. However, when it came to the actual facts of the case, it came to light that even after international shipping had found out that the audited financial statements were incorrect, so they knew of the correct state of affairs, they forwarded more money to D Group. They continued lending to them. And the argument accordingly was that they cannot say they based their decision to lend this money on the audited financial statements because they knew they were wrong and they continued. So this court case discusses and sets out these 5 requirements in great detail. That's why it's an important case. But at the end of the day, international shipping lost the case and could not succeed in getting their money back. Okay. That's literally all I wanted to teach to you this evening. Very, very important, though. I hope you understood. Are there any questions?
No, but I will definitely make a turn at your office on Monday, if possible.
Mr. Van Wyk, just before you come to my office, and all of you, before you come to my office, just WhatsApp me and make sure I'm there.
Yes.
I don't want you to rock up at my office and I'm not actually there. And sometimes on a Monday, because I don't have class on a Monday, I do have a work from home day. So I don't
Okay.
want you to arrive at, and on Tuesdays, unfortunately, I teach between 1 and 2. So
Mm.
just the invitation is there for all of you. Please, please do come to my office, but just contact me. I don't want you to arrive there and then my door is locked or I'm teaching. But otherwise, you are absolutely welcome. Any further questions? Mr. Mapenzi, you were quiet tonight.
Yes, I was in the library, so
Oh, so
yeah,
you
so
weren't
please,
quiet.
please.
You weren't quiet because you had nothing to say. You were just quiet because you weren't in a place where you could talk.
Yes, exactly.
Yeah.
So I only stepped out now. I think it almost, and now it's clear a little bit. It almost speaks to almost the usual case that happened with the SME bank. I think they took some periods without producing annual financial statements, and then they brought in auditors that audited them, but then I think they did not disclose in the annual financial statements very clearly of loans. These funds were listed in the annual financial statements as loans, but it's only when the second external auditors, which was BDO, when they came to audit the bank, they are the ones that brought
mm,
to the attention of the Banking Institution Act that it appears that not the Banking Institution Act, but the banking institution, to the attention of them that it appears that these funds are not with the bank, they are
mm.
not in their records. So yeah. So now my worry is that uh, is there not a case where an external auditor can now relate or maybe work under the influence of the company? But then again, it means they are not practicing as required.
Oh,
But I think it's clear now.
yeah, yeah, no, absolutely, Mr. Mapenzi. I made the statement that it's in most instances it will be negligence. Maybe because my late father was a chartered accountant and my daughter is a chartered accountant, and I have great faith in the professional integrity of the profession. But maybe I'm also a bit stupid in that regard. And you're quite right to say it is very, very likely that it can happen that the external auditors are actually in cahoots with the company. You can't rule that out. I don't like to think that, because you like to think of your auditors being all proper and honest and diligent and all of that. But unfortunately, we live in the real world and not all people are like that. So yes, it can hundred. And your example of the SOE bank um, is a perfect example where initially it wasn't picked up and then only at a later stage. Arunisia asked here, what if they are also deceived? Um, Arunisia has asked two questions. When do the fines against auditor take place? Arunisia, in the notes, but we don't do that in class. But the Companies Act itself uh, provides for certain instances where if the auditor doesn't do certain things, they can be fined. So that's, no, if you get a fine, that's because you were criminally liable. Remember, there's a difference between having to pay a fine and having a claim for damages. If I could just explain that slightly off topic. Let's say you are driving a car, which is also a delict, in an accident. You can be held liable for reckless and negligent driving and pay a fine which goes to the state. Or not alternatively, in addition, the person whose car you damaged can claim damages from you, which is civil liability. In the China scandal, Arunesia, they were fined, so they were held criminally liable. We still need to see whether anybody that lost money when this property developer went bankrupt eventually decides to claim damages from them as well. So there's a possibility of both. What if they are also deceived? In terms of the law of delict, you have to prove all 5 those elements. If you cannot prove that the auditor was negligent or intentional, in other words, they were deceived, they did their utmost, they did everything they had to do, but they were deceived, they will not be liable, because you will not be able to claim all 5 those elements. You have to at all times claim all 5 those elements. Okay. Further questions?
I also wanted to seek clarity on the fact that when the auditors are giving an opinion, it's not an absolute assurance, since part of their work is done on sampling. They do not test everything, and hence why they cannot give an absolute assurance. So I was worried mostly about the company which prepared the books, and is also having internal auditors, is now putting the whole blame on the external auditors. So to me, it feels like there is some sort of unfairness there, because you are having the financial guys who are preparing. After preparing, your internal auditors are checking, and then the external are coming to do the sampling, and then they give assurance, and the whole blame is being put on them.
Mr. Koromora, you raise a valuable point. But once again, we get back to the fact that in order to claim, it's not a matter, don't misunderstand me, it's not a matter of every single time when the company loses money, they can go and run and claim it from the external auditors. Once again, they have to prove those 5 elements. You are absolutely correct that it is not an absolute assurance that they give, because they only did sampling. And when they sign off, they say, to the best of their knowledge and abilities. The company will have to prove, the company, not the external auditor, the company who wants to claim will have to prove once again that they were negligent, that they should have picked it up if they had done sufficient checks. So we're not expecting of them to check every single thing. The concept of sampling is internationally accepted. So they don't check every single thing, but the company will prove that they did not have to prove that they did not do sufficient sampling, that they did not do sufficient checks, that the people that were working on the audit were not sufficiently experienced to pick up whatever. So the fact that I started off by stressing that auditors can be held liable does not mean they will be liable every single time. There's the possibility of them being held liable, but the company has to prove that they were negligent. Once again, you have to prove all 5 of those requirements. Just proving that they lost money isn't good enough. So No, it's not necessarily unfair. And remember, in a court case, the auditors also have the opportunity to defend themselves. So it's not an automatic liability that arises. If that was the case, obviously it would be grossly unfair. And then nobody would want to become an external auditor if they're going to be held liable every single time. I pointed out real life worst case scenarios to illustrate the fact, which perhaps made it sound as if this is a regular occurrence. It's in fact fairly rare that eventually they are held liable. But it can happen.
Yeah, sure.
Okay, are you happier now?
Yeah, I can smell.
Okay. Okay, great. Okay, any further questions? Okay, if there are no further questions, I'll say good night to you. Thank you so much for your patience with the struggle with my Teams and my laptop, everything in the beginning of the lecture. What I will try to do is, before I upload the recording onto YouTube, I will try to edit the recording and cut out the first part where there's just silence, and actually just start what I upload on YouTube from where I managed to upload the slides and the actual class started. Thank you so much. Have a wonderful evening. So next week then, revision. Thank you.
Thank you, ma'am.
Bye.
Thank you, ma'am. Good night. Bye.
Good night, Alicia. Good night, Aronesia.